Good morning, everybody, and welcome to the IBB Law webinar on the new UK points-based system coming in on the 1st of January and the end of free movement. My name is Richard Duval, and I'm joined by my colleague Manisha Fatania. We are both lawyers within IBB Law's employment and immigration team. We're going to, over the next half an hour or so, cover a number of topics in quite a short time frame. The topics we'll cover are the end of free movement, which is clearly imminent, touch on the status of EU citizens already in the UK and the EU settlement scheme, and then major focus for me will be on the new immigration routes which come in from the 1st of January, particularly the skilled workers, graduates and intercompany transfer routes. And then finally, I'll touch on frontier workers before handing over to Manisha, who is going to talk to you about right to work checks. So as we all know, free movement comes to an end on the 31st of December, and we'll be introducing the new points-based immigration system that will treat all applicants equally, regardless of whether they're EU citizens or non-EU citizens. So if you wish to recruit anyone from outside the UK from the 1st of January, you will need to apply for permission first under the new points-based system. Those EU citizens who are already in the UK and living here by the 31st of December, they'll be eligible, as are their family members, to apply under the EU settlement scheme, and they have until the 30th of June 2021 to make that application. Just touching on the EU settlement scheme, it's a talk in its own right, but it's free to apply. If a person applies successfully, they'll be able to continue living and working in the UK after the 30th of June. They will usually be granted either settled status or pre-settled status. Settled status will be given where someone is living in the UK by the 31st of December and they have 5 years continuous residence in the UK. Where someone applies and they haven't already clocked up the 5 years continuous residence, they will typically be given pre-settled status, allowing them to stay in the UK for a further 5 years, and therefore allowing them to apply for settled status at a later date. Just a few hints and tips, perhaps with the end of free movement, things to think about. We would suggest, if you haven't already done so, to have a look at your workforce, see what exposure, if any, you may have to EU workers choosing to leave your workforce and go back to their home countries, perhaps. You might want to carry out some form of audit of your workforce to assess that exposure, if any. It's an important time to communicate with your workforce and your EU nationals, particularly about the requirement for them to apply under the EU settlement scheme for settled or pre-settled status, and the fact that they have until the 30th of June next year to do so. We'd also suggest, bearing in mind where we are in the year, it might be that some of your EU national workforce are intending to go to their home countries for Christmas. Of course, that is going to coincide with the end of the transition period, and it's also going to coincide with the introduction of the new points-based system. It is possible that when they come back into the UK, questions may be asked at the border as to their status in the UK and what they're intending to do. So you might want to suggest to EU nationals who are travelling that they carry with them proof of their employment status in the UK, and indeed you might want to provide them with a letter that confirms their employment status in the UK. For those who intend to employ EU citizens from the 1st of January, and if you haven't already got one, you will need a sponsor license to do so. That application process is online. It's subject to the payment of a fee. If you're a medium or large sponsor, then the fee currently is £1,476, and a fee for a small or charitable sponsor is currently £536. You'll need to gather the information, documents together to show that you are a legitimate business in the UK, that you have genuine vacancies that you need to fill from the global talent pool, and that you have the processes in place to monitor any workers that you may sponsor under your sponsor license. Please ensure that you make the application sooner rather than later. Currently, the processing times with the Home Office are 4 to 6 weeks. And that could become longer depending on demand. So please bear in mind where we are in the year. Please make that application sooner rather than later. If you are currently a holder of a Tier 2 General license and indeed an intercompany transfer license, you'll automatically be granted a new skilled worker and intercompany transfer license, so you don't have to do anything there at all. If you already have a sponsor license, please check it's up to date and hasn't expired. Please check that those who've registered in the management roles for your license, so authorizing officers, key contacts, level 1 users, are still actually employed by the business. The number of times that we see or have clients where people have left that company's employment and the company has failed to update the license, which is a breach of the rules. So just please check everyone is present and correct under the license. If you are utilizing a Tier 2 intercompany transfer license currently, please check that all your legal entities around the world are actually attached to your sponsor license. It's possible that you may not have included any EU legal entities that you have because you haven't had to do so up to this point. But so please check carefully that every legal entity is covered by the license. Moving on to some of the new immigration routes, I think the most important of which is the skilled worker route. So from the 1st of January, anyone you recruit from outside the UK for the skilled worker route, they'll need to demonstrate that they have a job offer from you as a licensed sponsor, that they speak English to the required level, that the job offer that is being made is at the required skill level. And this is quite a significant change from the current Tier 2 General visa. That skill level is now reduced down to the equivalent to A level. Previously, it was the equivalent to graduate level. And finally, they'll need to demonstrate that they have been paid at least £25,600 or will be paid that. They can be paid less than that, but not less than £20,480 by applying what are called trading points. And I'll talk about that in a little more detail in a moment. But essentially, if you've specific characteristics of having a PhD or where a job offer is on the shortage occupation list, will lead to an ability to trade points. So a successful applicant will need 70 points to apply for a skilled worker visa. The job offer itself will give them 40 points. Being able to speak English to the required level will give them another 10 points. And you will get 20 points if you're paid the minimum salary of £25,600. As I said, there is this concept of trading points. So you can get extra points for better qualifications. If you've got a PhD, that will give you an extra 10 points. If you have a PhD in science or technology or maths or engineering, that will give you an additional 20 points. Or if the job is on the shortage occupation list at the time, that again will give you 20 points. Another major change from the current system is the fact that the resident labour market test that we have currently will no longer apply. So there's no longer, or will no longer be a requirement to advertise the position that you want to fill for a 28-day period. That of course means less paperwork for you. It means a faster process. We anticipate that will probably cut at least 4 weeks off the processing time for a certificate of sponsorship. And it hopefully will give increased certainty as well. So the whole idea of having to keep CVs, interview notes, job adverts, that all will disappear. As there is now, there will continue to be an immigration cap on the number of skilled workers. Sorry, there is no immigration cap going forward as there is now on skilled workers coming to the UK. So currently there's a cap set at 20,700 per year for Tier 2 General visa workers, which is split into monthly allocations. That cap is suspended. So there's no limit whatsoever on the number of skilled workers who can actually come to the UK. Hopefully, again, that will speed up the visa process and it will provide a lot more certainty. So you haven't got to worry about whether an allocation in a particular month has already been exceeded, which means you couldn't apply or be successful in that particular month. There is also going to be the removal of the cooling off period. That currently stops Tier 2 general workers from returning to the UK for a period of 12 months following the expiry of their visa, but that will no longer apply. So when someone's visa expires, they will be able to apply again should they wish to do so without a cooling off period. The immigration skills charge will remain. So currently employers must pay £1,000 per skilled worker for the first 12 months, and then with an additional £500 charge for each subsequent 6-month period. Now moving on to an entirely new route that we don't have currently. We used to have it historically many years ago, but it's been reintroduced when this is the graduate visa route. It's not going to become available until the summer of next year, but it will be available to any international student who completes a degree in the UK from next summer, and they'll be able to stay in the UK for a period of 2 years, and they can live and work here at any skill level. That 2-year period cannot be extended. Similarly, a PhD student who completes their PhD in the summer next year, they'll actually be able to stay in the UK again and work at any skill level for a period of 3 years. Again, it's not extendable. It's potentially a great route for business because it's a non-sponsored route, so you don't need a sponsor license to bring people in. And it has no fees attached to it, which is clearly an obvious advantage. From the graduate's point of view, they will be able to switch away from the graduate visa route should they wish into something like the skilled worker route, which will then potentially allow them to have permanent residency in the UK if that's what they're looking to achieve. Moving on to intercompany transfer visa route. Now, substantially, that is going to remain the same as the intercompany transfer route that we have currently. The role will still be required to be at a degree level, which of course will then be out of step now with the new skilled worker visa route. You will have to have a greater qualification in order to qualify under the intercompany transfer route. You will still need to meet the minimum salary requirement of £41,500, and it's still the position that you won't need to have any required level of English to have this visa, but it won't allow you, as again is the case now, it won't allow the person to establish permanent residency in the UK. However, unlike now, they will be able to switch from this visa into another visa route, for instance, skilled worker route, which does have that settlement upside should they wish to do so. There's a lot more flexibility around it. In order to qualify for a visa, an intercompany transfer visa, an applicant would need to have been employed by you for 12 months prior to their transfer to the UK. Alternatively, if they earn over £73,900 a year, they'll not need to have that 12 months prior service, and they'll be able to stay in the UK for up to 9 years in any 10-year period. There is also a change to the cooling off period. There is a cooling off period that will remain. However, it's going to be relaxed to allow more flexibility for workers who may be on shorter term assignments. So the rules in the future will allow intercompany transfer visa holders to be assigned to the UK multiple times for up to 5 years in any 6-year period. So it means they can come and go without having to apply the cooling off period every time they leave the country. And as I said earlier, please do double check your sponsor license if you are anticipating using the intercompany transfer route, that you have got included within it all of your legal entities around the world. And lastly, from my point of view, just going to touch on frontier workers. A frontier worker is an EU or a Swiss citizen for that matter who is employed or self-employed in the UK but living elsewhere in the EU. Their position could well become more complicated with the end of free movement. Some may be eligible for status under the EU settlement scheme, but many may not be because they haven't spent sufficient time in the UK to be eligible. But the government have introduced the Frontier Worker Permit Scheme to allow employees who have a Frontier Worker status now or before the 31st of December to be able to retain that status. They will need to apply for the Frontier Worker Permit. Last Thursday, so on the 10th of December, the government launched the scheme, so you can apply now. It's live and kicking. Applications are free. You can make the application online from either inside or outside of the UK. The application process is not dissimilar to the EU settlement scheme process. An applicant can use the Immigration ID Check app on their phones to verify their identity. If they are successful, they will normally be issued with a digital status, which is valid for 5 years. If an applicant doesn't use the Smart App verification app, then they'll actually be given a physical permit. In both cases, be it digital status or physical permit, an applicant can apply to renew the permit when it expires, providing, of course, that they continue to meet the eligibility requirements. It is important to note that Frontier Worker Permit doesn't actually permit someone to enter and leave the UK as they wish. It simply provides a right of admission. If someone wants more certainty or wants longer term benefits, they might want to consider applying under the EU settlement scheme instead and not relying on a Frontier Worker Permit. Until July next year, Frontier workers who already hold that status before the end of this year, they will continue to be able to enter the UK just simply by using a passport or national ID card. But after the 1st of July, they will need to hold the permit as well as have a valid passport or national ID card. For any Frontier Worker of the future, i.e. those who haven't got that status by the end of this year, they will have no option but to apply under the new points-based immigration system. At which point I'm going to pass over to Manisha, who's going to run through some hints and tips and points around right to work checks. There will be, I should have said earlier, when Manisha finishes, there will be an opportunity to ask questions, and please use the Q&A function as we go along, and we'll try and answer as many questions as we can at the end. If we haven't got sufficient time, where we can, we will follow up with any answers to the questions raised. Many thanks, and here's Manisha.
Thank you, Richard, and hello, everyone. So as Richard says, I wanted to spend a few minutes talking through the right to work checks and run you through what is changing as of the 1st of January 2021. As you probably already know, all employers in the UK have a responsibility to prevent illegal working. It is incumbent on all employers to identify whether or not the employee or worker that they wish to employ is able to work in the UK before they employ them. Illegal working is known to directly contribute to exploitation and can result in workers being underpaid for work that they do. Employing an illegal worker can have very severe consequences. The Home Office takes a very hard line against employers that intentionally or negligently employ individuals that do not have the right to work in the UK. Employers can be imprisoned for up to 5 years and can also face an unlimited fine if they employ somebody that was known or could reasonably have been known not to have the right to work in the UK. However, the upside is that provided that you carry out the right to work checks properly and you deem that an individual does have the right to work in the UK, you can rely on the statutory excuse to avoid penalties and criminal action if you are later found to have employed an illegal worker. The statutory excuse is a defence that can be relied upon in the event that an individual manages to fraudulently convince you that their documents are genuine or similar circumstances like that. Moving on to the practicalities of the right to work checks. So there are two ways to check an individual's right to work. You can do this both manually and online. It is prudent to check both ways, but you do not necessarily have to. If you have completed the manual right to work check, you do not have to complete an online right to work check. When doing a manual check, you should refer to the government website for the right to work checklist. You must check documents from either List A or List B from this checklist. List A contains a range of documents that can be accepted for individuals that have the permanent right to work in the UK, whilst List B contains the documents that can be accepted for an individual that has the temporary right to work in the UK. You must also retain a completed copy of this checklist on the personnel file. It is important that you complete a physical check on the original documents. Copies are just simply not sufficient. When completing the check, make sure to check that the name and the photographs on all documents match up. Ensure that the documents have not expired and that insofar as you can tell, the documents that you are being presented with are genuine. When checking the passports, you should check all pages of that passport. You should also take copies of all documents that you have checked and retain them on file. You should be signing and dating the check and when it occurred. It is important that the right to work check takes place before the individual starts work. Oh, sorry, I'm just moving the slides. It is important that when you it is important that the right to work check takes place before the individual starts work. Therefore, if you are checking an individual's documents on the same day that they are due to start work, you should also put a timestamp as well as a date stamp to show that the document was checked before the individual did actually start work with you. The paper trail is very important so as to ensure that the statutory excuse can be relied upon if needed. If the Home Office does ever do an audit of your workplace, that is what they will look to see, and they will check through all of your paper trail. So it's very important that that is kept accurate and that you have sort of a record of the checks that you have done. It is also important that you as an employer, you keep copies of the documents that you have checked for not only the duration of employment, but also for 2 years following the termination of the individual's employment. Moving on to online right to work checks. So in 2018, the government launched an online right to work checking service. This service is available on the government website and it is free to use for employers. It allows employers to access real-time immigration information about potential employees and workers. The online checking system is free to use and it's an attempt by the government to streamline the immigration system. However, it's not without its faults. Employers must be authorized by the individual themselves to be able to access their information. The online checks can be completed only if the individual has authorized the employer to check their information and if they themselves had used the online checking system themselves. When the applicant uses the online checking service, a share code is generated. The individual then shares that share code with you as the employer, and therefore you can then go ahead and input that share code into the system and check whether or not the individual has the right to work in the UK. The service is voluntary and it's not strictly necessary if diligent manual right to work checks have already been taken. If completing an online right to work check, make sure that you screenshot the results with an electronic date stamp and signature. This should be retained on file for at least 2 years beyond the date that the individual's employment terminates. So what's happening as of the 1st of January 2021? So what's happening as of the 1st of January 2021? Actually, not very much is changing in terms of the practicalities of the right to work checks. You are still obliged to follow all of the steps that we have mentioned and complete the checklist as outlined previously. You should still be checking passports and ID cards as you have been already. However, the government has announced that at the end of the transition period, a 6-month grace period will be enforced. During this period, employers are not allowed to discriminate against EU, EEA or Swiss nationals. EU citizens that enter the UK by the 31st of December 2020 are able to apply for pre-settled or settled status via the EU settlement scheme. Applications must be made before the 30th of June 2021. Individuals that enter the UK after the 1st of January 2021 do not have the automatic right to work in the UK, and they cannot apply via the EU settlement scheme. They must have a visa in order to work in the UK. That means that we have a big problem on our hands, because as of the 1st of January, we will have two types of EU workers in the UK. Those that can work by virtue of their status under the EU settlement scheme, and those that will need a visa to work. This is problematic in light of the grace period between the 1st of January and 30th of June. The government guidance explicitly states that employers are not able to ask individuals whether or not they have settled or pre-settled status until after the 30th of June 2021. This poses a huge problem for employers, and we're eagerly waiting guidance from the Home Office as to how we can navigate the right to work checks properly during the grace period. We will, of course, notify you as soon as we have some more guidance from the Home Office. However, in the meantime, employers must satisfy themselves that individuals that they seek to employ do have the right to work in the UK. You must therefore complete the right to work checks as outlined in earlier slides. As of the 1st of January 2021, you should also ask when an individual arrived in the UK. This will indicate whether that employee has or can apply via the EU settlement scheme. You are also able to encourage individuals to apply via the EU settlement scheme, so long as you're not explicitly asking them whether or not they have EU settlement or pre-settled status. If you are aware that an individual arrived in the UK after the 1st of January 2021, the reasonable assumption is probably that that individual does require sponsorship and does not have the automatic right to work in the UK. You should therefore take steps to ensure that if you are going to employ that individual does have the right to work in the UK via sponsorship or visa. So that's it for in terms of the right to work checks. I think we will now move on to questions. I believe that Richard will also be joining me for the questions.
I will indeed. So we've had a few questions come in. Many thanks for those. The first question I'd like to pick up on is someone's asked, can you require an EU employee to apply for pre-settled or settled status? And can you require an EU employee to actually show their status under the EU settlement scheme? The answer to both those questions is no. You can't force anybody to apply under the scheme. It's entirely a matter for them should they wish to do so. And you can't require them to show you their status until after the 30th of June. As I said, it's entirely the responsibility of the individual themselves to make the application. There's no requirement for them to inform me that they've done so or haven't done so, and they don't have to inform me as to the outcome of the application that they may or may not have made. So hopefully that answers that question. Another question that's come through is, if you're already in the UK under a visa route, would it be possible to switch into one of the new visa categories under the new points-based system whilst still in the UK? I think the answer to that question is yes, you should be able to. There's a lot more flexibility around switching going forward. So for instance, if you're on a tier 2 ICT visa now, you should be able to switch into the skilled worker route after the 1st of January whilst still being in the UK. So hopefully a lot more flexibility. I'm just checking on some other questions here. Just a question about how can we best do right to work checks during this working from home lockdown period. Manisha, have you got any thoughts on that one?
Yes.
I suppose a lot of it's around the using the online system, but
exactly. So you should be checking via the online right to work system to check if the individual has the pre-settled or settled status. But also the Home Office has published some guidance on their website about how to do online checks remotely. So using Zoom, you can sort of check documents and have a Zoom call to check that the individual is who they say they are and what their picture represents as well. But there is some explicit guidance on that, which is quite helpful on the Home Office website.
Great. Stephen, I can see you've raised a question about, again, about eligibility checks, and do new employees need to provide confirmation of settled or pre-settled status? Hopefully, I've already answered that question in an earlier answer to a question around, we've got this between now and the 30th of June. The answer to that is no, basically, and then after 30th of June, absolutely. So hopefully that answers that one. There's another question about skilled worker route. Can you please clarify the cost again? So there are fees attached to a sponsor license. As I said, if you are classified as a medium to large employer, the fee is currently £1,476 for that. And if you're a smaller employer, it's 500, forgotten the exact figure, £565, I think it is. There will also be a fee for the certificate of sponsorship. If helpful, it's possible these fees may change actually in the future, but we can set it out in a follow-up email as to the fees as they stand today and the different categories of fee that may be applicable. Just seeing if there's any other questions. Can you see any other questions, Manisha?
So one other question is, what happens if an individual does not apply via the EU settlement scheme until after the 30th of June 2021? So that's quite a big question, actually. And at the moment, we believe that individual will not have the right to work in the UK, even though they were present in the UK before the 31st of December 2020. So that individual will need sponsorship and will need a visa. They will not be covered by the EU settlement scheme if their application is made late. The Home Office might, as I say, update that guidance, but that's what we believe at this stage. So it is quite important, actually.
Manisha,
sorry, go on, Richard.
No, please carry on.
So it is quite important, actually, that you are encouraging your workforce to apply via the EU settlement scheme if you can now.
I can see there's a question from Karen. How do we ask when potential employees became resident in the UK, e.g. before or after 31st December? That is one of the areas where the government haven't been that precise at the moment. I think it's fair to say, Manisha.
Yes.
But in my eyes, I think you just asked the question.
Yeah.
I can't really see it being any more complicated than that, and it doesn't seem to me to be an unreasonable question to ask in those simple terms. It's what you do with it thereafter, which is the critical thing.
Yeah.
So just and also, if we have any other questions
you should also be asking that question at the same point in your recruitment exercise. So you shouldn't be pinpointing certain individuals and asking them at a later stage. So long as your recruitment exercise is sort of consistent, as Richard says, just ask the question.
Yeah. We've had one further question around what classes as acceptable evidence for settled status. The answer to that question is using the online checking, where you can share a code. They share a code with you, and then you check their digital status as to whether or not they have settled status. That is the simplest way of doing it, because it is a digital status that someone will hold. Just seeing if there's any other questions that have come through. Okay, there's a question. Can you also clarify the details around providing a genuine offer for the points-based system for an individual under this route? How long would the process take? So you need to have a genuine vacancy, and indeed, when you're applying for a sponsor license, you need to show that you will have a need to fill roles. So there is a genuine need to have a license in the first place. As to how you show whether there's a genuine vacancy, it's very much about having a paper trail, I think, and having something set up that explains why you think you need to go to the global talent pool, and why you think it can't be filled easily or sensibly by someone, by a UK citizen. So it's the paper trail that sits behind it is key, I think, for showing that genuine vacancy. It won't be something, it won't be a role that is generally at a lower skilled level. That won't be considered to be a genuine vacancy. A genuine vacancy needs to sit in the particular business model for your business, the particular business plan for your business. So it needs to look sensible, and in all facets genuine. I hope that answers that question. Again, no doubt the government will issue further guidance around that as we move into the new year. It is an evolving jigsaw in many senses. I'm just seeing if there's anything else that has come through. I can't see any further questions at this stage, but please, if you do have any questions that come to mind, please don't hesitate to share them with us, and we'll do our best to answer them outside of this webinar. We will send out a follow-up email following the webinar. We do offer a 30 minutes surgery, should you need it, on a free basis within the Employment and Immigration team. So if you want to discuss anything, just please let us know, and we'll do our best to organise that with you. As I say, details of that will be set out in the follow-up email that will be sent to you. So if there's no further questions, all I can say is thank you very much for joining us today, and wish you a very happy Christmas, and keep safe and well, and look forward to speaking to you again in the future. Many thanks for joining us today. Goodbye.